All right, guys, I am back. Got my water ready, and let's continue. Okay, let's continue. I'm back. All right. Post trial motion. Following the guilty verdict, Kelly moved for a judgment of acquittal and for a new trial pursuant to Federal Rules of Criminal Procedure 29 and 33. In his Rule 29 motion, Kelly argued, as relevant to this appeal, that his RICO conviction should be vacated because the government did not establish the elements of an enterprise by failing to establish the associated in fact members of the enterprise shared a common purpose of ensuring Kelly's illegal sexual activities by failing to demonstrate that the enterprise was distinct from the defendant, that the Mann Act violation were unsupported by sufficient proof, and of certain of the state law statute underlying the Mann Act violation, namely California Health and Safety Code 1209290 and New York Public Health Law 2307, were unconstitutionally vague. In his Rule 33 motion, as relevant here, Kelly asserted that he was denied constitutional effective counsel where counsel failed to adequately challenge certain jurors and potential jurors during voir dire. In a supplement Rule 33 motion, Kelly challenged, as relevant here, the district court's admission of evidence in certain uncharged act. The district court is in a through opinion deny each of the motion. Sentencing. The district court sentenced Kelly to 316 months imprisonment as to count 1, 10 years as to count 2, 6, and 8, and 20 years as to counts 3, 4, 5, 7, and 9, all to run concurrently. The court also imprisoned $100,000 fine and $40,000 assessment under the Justice for Trafficking Victim Act and $900 special assessment. In advance of sentencing, the government moved the district court for entry of restitution. In September 2022, the district court held the restitution hearing and in November 2022 issued an order of restitution in the amount of $668,018 to Jane and $78,981.72 to Stephanie. On December 7th, 2022, the court issued an amendment, the judgment reflecting restitution order. In August 2022, the government moved for an order directing the prison Bureau of Prison, BOP, to turn over money held in the appellant's inmate trust account so that it could be applied to the appellant their then outstanding financial penalties. The district court granted that motion prior to the restitution hearing. Argument. Point 1. The government adduced sufficient evidence of an enterprise. Kelly argues that the government failed to prove a racketeering enterprise because 1. The enterprise proved by the government lacked an illegal common purpose, and 2. The enterprise was not distinct from Kelly alone. These arguments are without merit, as the district court held in response to pretrial motion and post-trial motion style under Federal Rule of Criminal Procedure 29. Roman numeral 1, applicable law. A, standard of review. A defendant's challenging the sufficiency of the evidence at trial bears a heavy burden as the standard of review is exceedingly differential. United States versus Copeland. This court will sustain the jury's verdict if crediting every inference that could have been drawn in the government's favor and viewing the evidence in light of most favorable to the prosecution. Any rational tiers of fact could have found the essential element of the crime beyond a reasonable doubt. United States versus Capers. This court must apply the sufficiency test to the totality of the government's case and not to each element, as each fact may gain color from others. United States versus Gardinga. Moreover, it is well settled that this court will defer to jury's assessment by witness credibility. United States versus Glenn. Objection to jury's instruction, conversely, were reviewed de novo, reversing only where viewing the charges as a whole. There was a prejudicial error, United States versus coercion. When a defendant does not timely object to a jury's instruction, a challenge to the instruction is reviewed for plain error, considering whether 1, there is an error, 2, the error is clear or obvious rather than subject to reasonable dispute, 3, the error affects the appellant's substantial rights, and 4, the error seriously affects the fairness, integrity, and public reputation of judicial procedure. United States versus Miller. B. Waiver and forfeiture. This court has distinguished between forfeiture of a claim and which resulted from a failure to assert the claim in a timely fashion, and which does not prevent appellate court from reviewing the claim for plain error from waiver, which is the intentional requisition of abandonment of a known right, in which permanently extinguished the right to raise the claim. United States versus Polbozisi and United States versus Olano. In the context of a jury's instruction, when a party proposes an instruction or agrees that the instruction is acceptable, that party waives the right to object. See United States versus Mitchell. Defendant waives her right to challenge a jury's instruction on appeal because defense counsel confirmed they were fine. C. RICO enterprise requirement. To sustain a substantive racketeering conviction, the government must prove that the defendant participated in the affairs of the charged enterprise through a pattern of racketeering activity. 18 U.S.C. 1962, United States versus Zemlansky. Under the RICO statute, an enterprise may include any union or a group of individuals associated, in fact, although not a legal entity. 18 U.S.C. 1961, 4. The RICO statute provides that its terms are to be liably construed to effectual its remedial purposes, specifically holding that the very concept of an association is expansive. Boyle versus United States. To sustain a RICO conviction, an associate, in fact, enterprise must have at least 3 structural features: a purpose, relationship among those associated with the enterprise, and the longevity sufficient to permit these associates to pursue the enterprise purpose. statutory definition of an enterprise. In 18 U.S.C. 1961, 4 does not specifically define the outer boundaries of the enterprise concept and is obviously broad and has a wide reach. As to the purpose, structural feature, the Supreme Court held that such requirement was apparent from the meaning of the term in its original usage, i.e., a venture, an undertaking, or a project. An associate, in fact, enterprise is simply a continuing unit that function with a common purpose. United States versus Pierce. Kelly waived any argument that court instructed were legally erroneous. Kelly did not object to the district court's jury instruction, which recognized that the term enterprise included legitimate and illegitimate enterprises, and which required proof for an associate, in fact, that the individual have associated together for a common purpose of engaging in a course of conduct, without specifically whether that the conduct or common purpose must be unlawful. Indeed, the same language was included in the parties' joint purpose jury instructions. Styled as a government proposal with enumerated defense objection, but with no defense objection or request to insert illegal or fraudulent in the definition of the common purpose requirement. Nevertheless, after trial, Kelly argues that the evidence was insufficient to meet what he described as a requirement of the statute. A fraudulent or illegal common purpose shared by members of the enterprise. A purported requirement never submitted to the jury, nor even proposed by the defense before trial. To the contrary, the parties' joint proposed instruction adopted by the district court set a benchmark for the government to meet. The government met the mark, and Kelly now objects that the government did not introduce sufficient evidence for the jury to find that another previously unspecified requirement was met. But that is not how sufficiency challenge work. It claimed that there was insufficiency evidence to support a jury's verdict, as opposed to a claim of deficiency in instructing a juror, assumes the validity of the instruction. Kelly has waived any right to appellate review by agreeing to the language of the instruction. United States versus Benday. Abrogated on other grounds by Similania versus United States. Nor has Kelly raised any argument specific to the jury instruction on appeal. United States versus Greer. Failure to include argument in appellate brief waives argument in appeal. Number 3. It was not plain error to submit the jury to find that individuals share a common purpose that was not illegal. Even if Kelly's brief challenges the sufficiency of the evidence were interpreted to challenge the jury's instruction and to seek a new trial at which the government would be introducing evidence to meet elements that the defendant now claim are required. This challenge would fail. Kelly's statement of the law is wrong, and the district court instruction and ruling provide for plain error because he did not object and indeed jointly proposed. The relevant language in the instruction did not contain an error that was plain. Moreover, any error would have been harmless. First, the instruction were not error at all because RICO does not require that members of an enterprise share an illegal common purpose. This court is determining the scope of a statute begins with its language. If the statutory language is ambiguous, it, in the absence of a clearly expressed legislative intent of the contrary, that language must ordinarily be regarded as conclusive. United States versus Turkett. The term enterprise, as used in 1962C, includes any union or group of individuals associated, in fact, although not a legal entity. 18 U.S.C. 1961, 4. As the Supreme Court ruled in Turkett, the definition appears to include both legitimate and illegitimate enterprise within a scope. It is no longer excludes criminal enterprise than it does legitimate ones. RICO uses of the word includes as defined in enterprise indicates that the list is not exhaustive, but merely illustrative. The Congress intended that such harmful infiltration, regardless of a form, should be eradicated. Thus, Turkett held that the enterprise is an entity that, for present purpose, a group of persons associated together for the common purpose of engaging in a course of conduct. In support of his argument, Kelly cited to language in First Capital Assessment Management versus Satinwood that the individual comprising in the association, in fact, enterprise must share a common purpose to engage in a particular fraudulent course of conduct or work together to achieve such purpose. Emphasis added. Kelly asserts that, contrary to Turkett's clear language, a new element of fraud must also be present to prove an association, in fact, enterprise. But Kelly uses this language out of context. In Satinwood, the alleged common purpose was one ground in fraud to conceal assets from creditors and the bankruptcy court, and thus this court necessarily analyzed whether such common purpose has been adequately alleged. The same is true to the two district court cases in which Satinwood relied when speaking of a common purpose to engage in a particular fraudulent course of conduct. Quoting First Nationwide Bank versus Gelt Funding Corporation and citing Mall and U.S. Life Title Insurance Company of New York. In First Nationwide, the alleged common purpose was to defraud, which the district court determined was insufficient because the plaintiff had not specified any joining together as a group to perpetrate the fraud alleged, but instead has asserted only a series of discontinuous independent fraud. And in Malls, the defendant argues that the plaintiff was not sufficiently proved that is an enormous group of real estate attorneys and other individuals engaged in the real estate settlement industry in New York constitute an enterprise where the alleged common purpose was provided real estate settlement services to purchases of residential real estate and maximizing illegal kickbacks. Each of these cases and Satinwood preceded the United States 2009 decision in Boyle, which held that to prove an association in fact enterprise, their enterprise need only have a purpose, relationships among those associated with the enterprise, and longevity sufficient permit these associates to pursue the enterprise purpose. Mali and First Nationwide cited Turcotte's standard that the group must have a common purpose of engaging in a course of conduct. And that's the standard of for enterprise. And the statute does not require that an enterprise be grounded in criminality. But in the civil RICO case cited by Kelly and the Satinwood court, the common purpose alleged was the alleged course of fraud, leading those courts to use the language cited by Kelly. The same is true for the published and non-published case in its circuit that cite the portion of Satinwood, C. IG Cruz versus FX Direct Dealer LLC, unholding dismissal of a civil RICO claims where complaint alleged the company was the RICO person, and the other entities were unaware of the common purpose of employing the multiple deceptive, abusive, and fraudulent act described in the amended complaint. Notwithstanding the language used in Satinwood and cited by Kelly, it is well established that the enterprise may have a common purpose of engaging in a wholly legitimate course of conduct, and there is no requirement whatsoever that the enterprise member have a common purpose of fraud or any other criminality. Indeed, Turcotte made clear that the enterprise as defined in RICO is distinct from Racketeering Act. The enterprise is a group of persons associated together for a common purpose of engaging in a course of conduct. The pattern of racketeering activity is, on the other hand, a series of criminal acts as defined by the statute. The former is proved by evidence, and the various associates function as a continuing unit. The latter is proved by evidence of the requisite number of acts and the racketeering committed by the participant in the enterprise. Turcotte, and then give a case number. In this court, in reinstating RICO claims dismissed by the district court, determined that an association is in fact enterprise exists where the shared purpose was one prescribed by law, settling the real estate by paying off its debt and distributing its asset among the heirs. Okay, municipal entities were part of the association in fact. Enterprise, despite the municipalities, cannot be found to have acted with unlawful intent for a common purpose because neither the indictment nor the jury instruction compare the conclusion that the city itself had to have formed an unlawful intent. And citing Turcotte, United States versus Feldman. RICO does not require intentional or purposeful behavior by a corporation charged as members of an association in fact, because they may be entirely legitimate and need not benefit from the racketeering. In fact, the criminal activities charged may harm each individual corporation by looting it, and a corporation may be used by the defendant to line his or her pocket. Okay. To read a requirement into associate in fact enterprise, that the group must have some sort of illicit, much less fraudulent common purpose would run contrary to substantial Supreme Court and Court precedent that explicitly do not require as much, and would be directly contrary to RICO's purpose and undermine an organized crime influence upon legitimate businesses and the need to protect the public from those who run organization in a manner detrimental to the public interest, as Kelly did for decades. RICO's response to a new situation in which person engaged in long-term criminal activity often operate wholly with legitimate enterprise. The plain language and purpose of the statute contemplate that a person violates the statute by conducting an enterprise through a pattern of criminality. Recounting legislative history that the purpose of a RICO is the elimination of the infiltration of an organized crime and racketeering into legitimate organization operating in interstate commerce. At a minimum, Kelly has failed to establish that this district court error was plain. The Supreme Court jurisprudence and second court case law in the criminal RICO context all support Judge Donnelly's thoughtful position on the requirement of the common purpose among the members of the association in fact, SPA 87-91, and any error in her ruling was far from plain. Finally, for the same reason discussed in FR, any error would have been harmless. Kelly has not established plain error in the jury instruction. The evidence of the charge common purpose was overwhelming. The evidence at trial established that Kelly and his inner circle shared a common purpose alleged in the indictment, promoting R. Kelly's music and R. Kelly's brand and recruiting women and girls to engage in illegal sexual activity with Kelly to produce pornography, including child pornography. The evidence proved that Kelly used his fame and popularity in the music business, combined with a network of individuals at his disposal, to target, groom, and exploit numerous victims for his own sexual gratification. First, Kelly conceded that his inner circle generally shared a common purpose of promoting his music. As detailed above, that conceded proved purpose combined with the other structural features of an association in fact enterprise, namely relationships among those associated with the enterprise, the longevity sufficient to permit these associates to pursue the enterprise purpose, is sufficient under the law and the instruction given by the district court. Kelly nonetheless urges his enterprise common purpose of promoting R. Kelly music and R. Kelly's brand was insufficient because there was no nexus between the objective of the enterprise and the racketeering activity. But as the district court determined, the insufficiency argument failed on that fact. Nexus between RICO enterprise and the Predicate Racketeering Act may be established by evidence that the defendant was able to commit the predicate offense solely by virtue of his position in the enterprise or involvement in or control over the affairs of the enterprise, and not the predicate offenses are related to the activity of that enterprise. United States versus Minicone. The trial included lengthy testimony from Kelly's victims and members of his inner circle. about how his employees and entourage manage not only his professional life, but also the recruitment and maintenance of Kelly's victims. See Supra at 4-8. They provided Kelly's number to and otherwise recruited women and girls for him. Distribute non-disclosures agreement, escorted female guests and tended to their needs, made travel and hotel arrangement for victim, shuttled his recording equipment around, and picked up his herpes medication. Kelly funded a machinery of individuals tending to his every personal need, including grooming, maintaining, and even acting as Kelly's guard over the women and girls with whom he was engaged in illegal sexual activity. This machinery enabled him to commit the predicate offenses solely by virtue of his position in the enterprise or involvement in or control over the affairs of the enterprise. Nor can there be any dispute that the predicate offense are related to the activities of the enterprise. ID. Where the evidence established that almost every single victim was recruited or coerced into a sexual activity with Kelly because of his position in the music industry, a position promoted by Kelly's inner circle. CIE Super at 9. Aaliyah was an inspiring musical artist. 15. Kelly demanded oral sex before auditioning Jane. 19. Kelly associate recruited Faith at a concert by inviting her backstage. 27. Sandra met Kelly at her kickstart her career at a radio station. See also IEID at 11. Kelly used Stephanie's desire to introduce a friend to sing for Kelly to arrange to have sexual intercourse with Stephanie. 23-24. Angela aspired to sing and had sexual intercourse with Kelly as a minor because he told her she had to pay her dues. 25. Kelly recruited Addie and ensured that he was able to pursue an intercourse with her. 29. Lewis met Kelly because his mother believed Kelly could help Lewis as an inspired musician and asked Lewis what he was willing to do for music before sexual encounter. Second, the same conduct also proved that the second common purpose alleged in the indictment, that members of the enterprise recruited women and girls to engage in illegal sexual activity. Some, like Smith and McDavid, actively assisted in the predicate act, bribery, so that Kelly could not face repercussion of his illegal sexual activity with Aaliyah. See Super at 9-11. Others enable his exploitative, coercive, and force-related conduct by enforcing his punishment as such by standing guard over Kelly's female guests. See Supers at 6-7, 18-19. Kelly confronted Copeland about how she let Anna escape and enlisted her to monitor what exactly Jane and others did on their phone. ID at 7. See also ID at 21, describing how Copeland directed Faith's whereabouts, including her ability to use the restroom. He employed the Mayweather assistants to ensure women did not break his rule, even docking pay when they failed to comply with enforcing rules pertaining to his girlfriend. ID at 7-8. Others helped manage Kelly's exposure of herpes to other women. Super at 16. Juice helped Jane obtain herpes medication. 33. Anna STD result went to Copeland. Kelly Inner Circle also maintained discipline over Kelly's victim, thus helping to ensure his demands were met. C Super at 17. Drews oversaw process drafting Jane's false letters. 23. Russell sent threatening texts to Faith and her mother and posted graphic photos of Faith after she proceeded with her lawsuit against Kelly. 27 and 28. At one of Kelly's associates named Sandra signed a confidential agreement and instructed her not to fuck with Mr. Kelly. 32. Kelly associate provided Anna with a non-disclosure agreement to sign, and Anna provided collateral to Copeland. See also GA 1049-42 transcript recording of which Kelly indicates his engineer were monitoring and downloading video surveillance. And there was ample evidence for the jury to conclude that Kelly's Inner Circle knew and turned a blind eye to the fact that at least some of Kelly's girlfriends were minors. Novato, one of Kelly's runners, described girls helping transport as looking pretty young, like mid-aged teenager. Officer described how he responded to Kelly's residence and spoke with McDavid looking for a missing juvenile. Mac, arranging Jane's travel, aware of Jane's birthday, indicated she was a minor. Mac described the observing sexual act between Kelly and Jane. Suzette describing that she knew Jane was a minor and had heard Kelly physically abuse Jane. Describing how Bruce, Kelly, and Hood were in an apartment while Kelly engaged in sexual act with minor high school students. The enterprise alleged by the government and found proven by the jury was one comprised of an inner circle who shared a common purpose of engaging in course of conduct. The inner circle worked together to promote Kelly's music and his brand and to meet his personal needs, which included recruiting women and girls, including the illegal sexual activity, viewing the evidence in light of most favorable to the government. As this court must, the evidence of the enterprise were more than sufficient. The enterprise was distinct from Kelly. Kelly also asserted that the government's proof of enterprise failed because it did not demonstrate that Kelly was distinct from the enterprise. Again, he is wrong. At trial, the government offered evidence that Kelly surrounded himself with his inner circle, and Kelly and his inner circle together worked to promote his brand and to meet his personal needs. Because the enterprise was comprised of Kelly and his inner circle, it is sufficient distinct from Kelly. Kelly's reliance on a series of cases where the defendant was a corporate entity is inappropriate. For example, Riverwood, Chappaqua Corp. And Marine Midland Bank, N.A. The defendant was a corporation, Marine Midland Bank. Their enterprise consists of a bank employees acting in the course of their employment and on behalf of the corporation. This court explained that where employees of a corporation are associated together to commit a pattern of predicate acts, in the course of their employment and on behalf of the corporation. The employees of association with the corporation do not form an enterprise distinct from the corporation. As this court reasoned, because a corporation can only function through its employees and agents, any act of the corporation can be viewed as an act of such an enterprise, and the enterprise is in reality no more than the defendant itself, ID. The same is true of other cases in which Kelly relies. All right, gave a case. Deciding distinctly requirement unsatisfied where holding company and two of its subsidiary were named as both RICO defendant and RICO enterprise. Because entities were part of unified corporation structure, the guided by a single corporation consciousness vacated on other grounds. This is not the case where a corporate entity was both the RICO defendant and the RICO enterprise, or where Kelly was simply associating himself. Rather, as in Cedric Kushner, the enterprise, which consists of Kelly's inner circle, was distinct from Kelly. C533 United States at 163, holding the corporate employee who conducted the corporation affair is a RICO forbidden way. Satisfied distinctiveness requirement because a corporation owner / employee, a natural person, is distinct from the corporation itself. CID. Holding distinctiveness requirements satisfy where either formal or practical separateness exists. McCullough versus Sutter. Holding what were defendant had several people working for him. This made his company an enterprise and not just one-man band, not just a one-man band. Point number 2. The government adduced sufficient evidence to support the jury's verdict as to the remaining counts. Point 1, part 2, supra discussion. Counts 6 and 9 in Racketeering Act 8A, 12A, and 14A, transport with intent to engage in illegal sexual activity. There was overwhelming evidence that Kelly transported Jane and Faith with the intent of exposing them to herpes, in violation of 18 U.S.C. 2421, as charged, a Racketeering Act 8A charging an underlying violation of Section 120290 as to Jane. The Racketeering Act 12A and 14A and count 6 and 8 charging underlying violation of Section 2307 in New York Penal Law 120.20, Section 120.20, as to Faith, Georgia 2832, GA 28, 32, 34, 37 through 38, as the district court correctly instructed the juror to establish the necessary intent for a violation of Section 2421. The government must prove beyond a reasonable doubt that sufficiency or motivating purpose of the travel across state line was the defendant would agree in illegal sexual activity with the victim. In other words, that illegal activity can't have a merely incidental to the truth. Kelly did not challenge the juror's instruction on appeal, but argues the illegal nature of the sexual activity, though not the sexual activity itself, was incidental to the trip. In other words, he intended to have unprotected sex with Jane and Faye, but did not intend to expose them to herpes. However, the plain text of Section 2421A which prohibit the knowing transport of any individual with the intent that such individual engage in or any sexual activity in which any person can be charged with a criminal offense, required that the jury to determine as it did that the defendant transported Jane and Faith with the intent of engaging in sexual activity with them, and that the intended sexual activity was illegal. United States versus Perkins, which prohibit crossing state line with intent to engage in a sexual act with a person who has not attained the age of 12 years. Proof of two element must be met: crossing state line with intent to engage in sexual act with a person, and second, the person must not have attained the age of 12. One of Kelly's motivating purpose of transporting Jane to California was to engage in unprotected sex in his usual manner without first informing her that he had contracted herpes, attaining her consent to sexual intercourse. In those circumstances, Kelly's argument on appeal that the jury verdict in this case was based on a travel plus a violation of state law that resulted that the fact simply ignores the factual record in this case. Medical records and testimony established that Kelly had contracted genital herpes at some point before March 2007. Kelly knew that this diagnosis and that he should inform his sexual partner that he had herpes and use a condom during intercourse. Failure to do so made his unprotected sex a state crime, and he traveled with the intent to commit that crime was itself a federal crime. There was no overwhelming evidence showing that Kelly's motivating purpose in spending time with Jane was to engage in sexual activity with her. The relationship began as a sexual relationship when Kelly and Jane could not audition with him. When she could not audition with them until he ejaculated. And thereafter arranged and paid for Jane to travel to see him on tour for sex. He wanted to teach Jane a few musical technique. However, he needed to ejaculate again before doing anything. Each of the following trips encounter involved sex. In summer of 2015, Jane and Kelly had sex almost every day. Kelly did not use a condom and never told Jane that he had previously been diagnosed with herpes. The juror could reasonably conclude that one of Kelly's motivating reasons for arranging for Jane to travel to see him in California in April and May of 2015 was to have sexual intercourse with Jane in the manner he always did with Jane and his other sexual partners, who testify at trial without a condom and without first informing her of if he contracted herpes. The same is true for Faith. Faith testified that after meeting Kelly, he arranged for her to travel to see him on various occasions to engage in sexual activity. On one trip to see Kelly in California, when Faith told Kelly she was on her period, Kelly asked her, "Well, why did you come?" At no point did Kelly tell Faith that he had herpes or wear a condom, including during sexual intercourse. A reasonable juror would certainly have concluded that a motivating purpose of having Faith travel to see him was to have sexual intercourse with her in a manner he always did, without condom and without first informing her of that he had herpes. Okay, count 7 and 9 in Racketeering Act 8B 12B and 14B, persuading, inducement, enticing, and coercion. Kelly next argues there was insufficient evidence to prove that he persuaded, induced, enticed, or coerced Jane and Faith to travel to engage in sexual activity that exposed them to herpes, as charged in Racketeering Act 8B, charging an underlying violation of Section 120290 as to Jane. Racketeering Act 12B and 14B, and count 7 and 9, charging underlying violation in Section 120.20 and 2307 as to Faith. Kelly argued that he did not persuade, induce, entice, or coerce Jane to travel to California in April and May 2015, but rather that Jane, a minor, deceived Kelly, citing the various text messages between Jane and her mother. He also argued that Faith was an adult woman who accepted his invitation to New York, which is not adequate into inducement or persuasion. The verb persuade, induce, entice, coerce, as used in 18 U.S.C. 2422, do not include as necessary element of overbearing or transformation of another's will. United States versus Wagger. Rather, a person may persuade to take an action to which she is already predisposed or natural, because otherwise the focus would move the locus of the offense conduct from the intent and the action of the word to persuader to the effect of his word and deeds on his would-be victim. A view of the statute this court has specifically rejected. Although Kelly attempted to flip the focus of the evidence to Jane and Faith, Kelly's own actions reflect attempt to persuade, induce, or entice Jane and Faith to engage in legal sexual activity with him. At Kelly's first meeting with Jane, he persuaded her to engage in a sexual contact with him, telling her that he needed to ejaculate before he could audition her. He then told Jane, an aspiring professional singer, that he wanted her to travel to see him on tour, promising to teach her singing technique and arranging a trip to California paid for, flights and hotel included by Kelly. A jury could thus readily conclude that Kelly persuaded, induced, enticed Jane to travel to California with false promises of assisting her with her singing and by arranging and paying for her travel, regardless of whether she expressed or felt reluctancy or indifference, or for that matter enthusiasm at the prospect of doing so. Plan to bring candy to anticipate sexual encounter with a child was sufficient to sustain conviction of attempting enticement of a minor in violation of 2422. Kelly's argument as to Faith failed for the same reason. Based on the evidence set forth above, including that Kelly told Faith he loved her, invited Faith to see him, assured her that the trip would be fun and she could see how he is on tour, and arranged and paid her travel, the jury could reasonably conclude that Kelly induced her to travel to New York so that they could engage in sexual intercourse. United States versus Raskowski. Defendant offered to make and pay for necessary travel arrangement, and victim thereafter traveled with his assistant, was sufficient evidence from which a rational juror could conclude that the defendant persuaded, induced, enticed them to travel. Concluding the defendant induced a woman to travel by making her travel arrangement, even though the woman has been willing to travel to work as a prostitute. And as discussed, the juror had a strong basis to infer that Kelly's intent consistent with his standard practice was to have unprotected sex without informing Faith that he had contracted herpes. Racketeering Act 9BD, unlawful sexual encounter with a minor. Kelly's transportation of Jane to California was done for the purpose of engaging in sexual activities with a minor, notwithstanding his implausible claim that the sex he had was with a 30 teenager 30 years his junior, was pure incidental to her transportation there. Kelly's argument is premised on the claim that he went to California to perform rather than to have sex. But the evidence shows that Kelly had sex with Jane while she was a minor almost every day in the summer of 2015, including while he was on tour. Jane had no role in planning the tour or Kelly's performance, nor does Kelly claim as much. The juror was free to infer that Kelly took Jane on those trips to engage in sexual activities with her, and that activity was illegal. Finally, Kelly's argument as to Racketeering Act 9B and 9C failed for a similar reason. The jury properly inferred that Kelly's induced, persuaded, enticed, and coerced Jane to travel with him from New York to California and beyond when he arranged for her parents to enroll her in a virtual high school, authorized Drew's mother to serve as guardian, and 3, arranged and paid for her travel. As detailed above, the case law forecloses Kelly's suggestion that he did not induce, persuade, entice, or coerce her because she may have agreed to travel with Kelly. Count 6, 7, 8, 9, and Racketeering Act 12 and 14, New York Penal Code, Penal Law, Section 120.20. Kelly's argument regarding Racketeering Act 12 and 14 and count 6 through 9 relies on his conclusory assertion that unprotected sex with someone who carries the herpes virus does not establish a substantial risk of serious physical injury, as required by Section 120.20. As the court properly instructed the juror, a substantial risk of serious physical injury occurs when a person engages in conduct which creates a substantial and unjustifiable risk of serious physical injuries to another person, when he is aware of and consciously disregard that risk, and when the risk is such a nature and degree that disregard of it constitute a gross deviation from the standard of conduct that a reasonable person would observe in the situation. Serious physical injury means impairment of a person's physical condition that creates a substantial risk of death, or that causes death or serious protracted disfigurement, or protracted impairment of health, or protracted loss or impairment of function of bodily organs. Kelly asserts that unprotected sex with A person carrying genital herpes does not establish substantial risk or serious bodily injury because not every sexual encounter means that herpes will be passed on, and that if passed on, it will result in serious physical injury. But the evidence shows that one, herpes is very contagious, transmitted virus. Two, it can be spread even while the carrier asymptomatic does not have a blister or other overt symptoms. And even if he is on antiviral medication like Valtrex, it varies in ranges of 10 to 20%, where there is still the possibility of transmitting it. And even that percentage range depends on the carrier's faithfulness, abiding by their medication regimen. And three, Kate and James contracted herpes prior to Kelly's exposure to Faith in the same. Further, Dr. McGrath informed Kelly that he needed to tell his sexual partner that he had genital herpes to obtain their consent and to use condoms. For New York State reckless endangerment, it was sufficient that defendant consciously failed to do what every physician testified he should have done. In that case, immediately transport a distressed patient to a hospital. Then section 120.20 requires recklessness, i.e., gross deviation for a reasonable person's standard of conduct and consciously disregarding a substantial and unjustified risk. Kelly also recycled his unsuccessful argument that herpes is not deadly and rarely causes any serious contracted health impairment, and according to him, thus cannot cause a substantial risk of a serious physical injury. But as this district court outlined, the trial evidence permitted a rational juror to find that herpes constitute a minimal of contracted impairments of health, including that herpes was permanent and incurable, with recurring outbreaks that cause severely painful physical and psychological side effects and risk cause other medical complication. People versus Williams, defendant engaging with unprotected sex with victim knowing he was HIV positive and without informing victim of HIV positive statute constitute second degree recklessness and endangerment. United States versus James. Transmission of genital herpes constitute a permanent or life threatening injury under the United States sentencing guideline. Merrick versus Algen. Reversing district court determination that genital herpes was not a serious medical condition under the Eighth Amendment. For all these facts, a reasonable jury could find, as the trial jury did, that Kelly conduct created a substantial risk of protracted impairment of health. New York Penal L 10.10. E. Racketeering 6 and 13. Forced labor. What's the topic? We're reading the brief reply for a reply for the New York Appeals Court for Robert Kelly. This is the government's answer to this stuff. Yeah. Okay, racketeering. Kelly challenges the sufficiency of the evidence proving that predicate racketeering act alleging forced labor in violation of 18 U.S.C. 1589, Racketeering Act 6 and 13, as to Geronda and Faith, similarly failed. To convict the defendant of forced labor, the government must prove: one, defendant obtained labor or service of another person; two, the defendant did so through threats of serious harm and to physical restraint against that person and any other person, or but through a scheme, plan, or pattern intended to cause a person to believe that non-performance will result in serious harm or to physical restraint against that person or any other person. And three, that the defendant act knowingly. Okay, that's it. There is no legal support to Kelly's claim that a sex act, whether one or many, does not qualify as labor or service unless there is a commercial aspect of the incident, or the victim expected to receive a benefit from the act. That ignores the text and purpose of the statute, which prohibit obtaining labor and services through force, restraint, and intimidation rather than reumberation. I don't want to say that word. This court recently rejected its similar claim, determining that the ordinary meaning of labor encompasses the expenditure of physical or mental efforts, especially when fatiguing, difficult, or compulsory. United States versus Ranieri. Further, service meaning the performance of work commanded or paid by another. United States versus Marcus. These definitions require no commercial aspect, as Kelly suggested is required, nor does it make any sense, as Kelly claimed, that the victim of forced labor would expect any type of benefit from the act. Kelly's conduct as to Geronda and Faith fell squarely within the plain language of the forced labor statute. After grooming Geronda approximately 6 months and punishing her when she violated Kelly's rule, after obtaining false statements from Faith to use as collateral and threaten her with a firearm, Kelly obtained services, i.e., oral and vaginal sex from Geronda and Faith, by explicitly threatening physical harm as they did not comply. Kelly's argument to the contrary is contradictory. He asserted without support the statute was not intended to address isolated acts as assault that are squarely within police power of the state, but then claims that the sex acts were not the product of assault, asserting that they were not given out of fear or threats of violence, notwithstanding the prior assaultive behavior. In any event, as the district court determined, Kelly's conduct, physical and psychological coercion intended to make his victim submit, is not traditionally addressed by the state law. Kelly used a variety of tactics over time designed to cause his victim to serve him. Conduct that fell squarely within 18 U.S.C. 1589 prescription of does not interfere with the enforcement of criminal activity traditionally reserved for the state. Finally, contrary to Kelly's argument, the evidence was sufficient to permit a jury to find Kelly's obtained sex act from Geronda and Faith through the threats of serious harm to them and through the scheme and plan or pattern intended to cause them to believe that non-performance will result in serious harm or physical restraint. As the district court recounted, Kelly punished Geronda when she failed to follow rules, including through physical violence, writing false letter, and in January 2010, Kelly slapped Geronda, choked her into unconsciousness, spit in her face, and told her to put her head down in shame because forcing her to perform oral sex on him. Kelly similarly monitored Faith punished Faith for violating his rule, and ultimately brought Faith into a small room with a gun and moved the gun next to him and directed her to perform oral sex on him. When Faith did because she felt intimidated and not free to leave because she was under his rule and he had a weapon. The jury thus had ample support for this conclusion that Kelly obtained sex from Geronda and Faith as a result of his scheme, plan, and pattern intended to cause the person to believe that if that person did not perform such labor or services, that person or another person would suffer serious harm or physical restraint. Okay, y'all, we got a lot to read, and I'm getting tired. It's been an hour. Yep, it's been an hour. It's time for me to go to bed, y'all. Look at my eyes. I'm so sleepy. Okay, we are on page. Let's see. We're on page 77. We'll continue tomorrow. I'm tired. Okay, and I got to get up early in the morning because I got affirmations. I got all this stuff, and I did not even get a chance to do to play what happened today in court. Oh, I needed to do that. I need to do that, y'all. I'm tired. I gotta clean up my stuff. Girl, I'm going to bed. I ain't giving no thoughts. I'm going to bed. Y'all give yourself some thoughts on your own. I'm going to bed. All right. Good night, good people. They say give thoughts. I'm not giving no thoughts. I'm going to sleep. I'm too tired. Good night, everybody.